A trust administration happens when any settler passes away or becomes incapacitated. Since there was a living trust involved, there would be a trust administration. You see, a living trust contains language that spells out what happens when a settler becomes incapacitated or when one or both of the settlers have died. That language requires certain actions by the backup trustees, sometimes the surviving spouse in the case of marriage. The administration part is when the attorney works with the surviving spouse or the backup trustees to follow the directions written in that trust and to make sure the trustee follows the requirements of the law. For example, if someone has died and they have a living trust, the assets that were in that individual's trust must be given to the next in-line beneficiaries. Or, in the case of a married couple, on the first death, family trust assets must be allocated or given to a subtrust for the use of the surviving spouse. A trust administration requires an experienced attorney at this critical time. There are state, federal, and county guidelines and rules that must be followed to save time and money. Often there are deeds and forms that are time sensitive, and delay can cause serious problems, unnecessary expenses, or missed tax-saving opportunities. Plus, the surviving spouse or other beneficiaries want assurances that they will receive what they are supposed to receive in a timely, efficient, and cost-effective manner. The first step usually involves the attorney reviewing and explaining the trust to the backup trustees or surviving spouse, as the case may be. This is true whether there's an incapacity of a settler or a settler has passed away. Then the attorney outlines the plan of action based upon the trust language. We think it's critical that the surviving spouse or backup trustee understands the process so that they can make informed decisions. Think of all this like a team, each person working toward the same goal. What does the surviving spouse or backup trustee usually need to bring to the first trust administration meeting with the attorney? Typically, let's use the death of a spouse as an example. The surviving spouse would bring in the original trust plan, about 4 or 5 death certificates, a list of the future beneficiaries' names, addresses, and contact numbers as well. It's also a time saver if the backup trustee, or surviving spouse, has a list of trust assets and the deeds or statements that go with each trust asset. In our office, we go through this process step by step. We clearly outline the goals and duties to make sure everything is clear and understandable so that the trust administration is wrapped up in a timely, efficient, and economic manner. Our office has handled trust administrations throughout the state of California. Even if our office didn't draft the trust, we can handle the trust administration. You can count on us in your time of need.